And hi, Kevin. We'll just keep going around the room. Hi, Bill. There's Bill. Hi, good afternoon, everyone. Thank you. So it's time to get started. And as our post-lunch panel, we're going to focus on international cases and international law. My name is Tracy Bach. I'm a professor of law here at the Vermont Law School. And I have just the sweetest gig ever because Margaret and Hannah invited me to step in and take all the glory in moderating this amazing panel that they put together. So before I do anything else, I want to offer up a congratulatory clap and applause for the great work they've done putting this together. So I'm sure you've heard several times today about Christopher Stone's work and the rights of nature. Do trees have standing? And one of the things that I think is fascinating about the panel this afternoon is that we are not only living in a period now, but have really over the last, 30 years or so since the height of environmental law in the United States, not really lived up to that promise that he was seeking to explore. It's really happened outside the US, and that's why this afternoon's panel is so important. So we have 3 speakers to talk with us today, and we actually met last week, talked a little bit about what they were going to say today, as well as the work that they do more widely than their presentation today. And we decided that we'd start with Craig, and then move on to Hugo, and then move on to Rachelle. Or Rachel. You get to choose, I've asked. So first of all, Craig Kauffman is going to be talking with us and setting the stage for how other countries outside the United States have both legally and probably more as a normative behaviorally and from a political science point of view, established the rights of nature and acted on that. Then we're going to turn to Hugo Echeverria, who has come here to us from Ecuador, where actually Craig did a fair amount of his early work. And he's going to talk about what's happening in Ecuador these days. And then finally, Rachelle will finish up today and talk with us from her point of view, having been in Israel's environmental ministry, and then more recently having founded a leading community-based and award-winning environmental organization. We're going to talk about water, we're going to talk about trees, I think we're even going to talk about some animals in there, we decided. So I think the best moderators are the ones that say hello, introduce the panel, and then step away. So without further ado, Craig Kauffman.
Thank you for sticking with us. It's been a long day, I know, and you're tired, so I'll try to keep you awake. I'm actually going to talk about 2 of the more recent instantiations of rights of nature laws. November 2016 ruling by Colombia's Constitutional Court, which as Grant said earlier this morning, recognized the Atrato River as a legal person and recognized specific rights there. And then also a ruling by the Uttarakhand High Court in Uttarakhand State in India that similarly had a ruling that recognized 2 rivers, the Ganga, or the Ganges, but I'll refer to it as the Ganga, because that's how it's referred to in India, and the Yamuna rivers in India. And the reason why I chose to talk about these cases, partly just because they're new cases, and so they're interesting to me, but they show the diffusion and adaptation of rights of nature legal provisions, right? So there were some of these early cases, like in Ecuador, which provided one model, and so you see similar kinds of laws in the US, Ecuador, Bolivia. And then, as we heard earlier from Kathy, New Zealand really pioneered this new different model. And then what you see since then is the diffusion of these 2 different models in different places. I'm going to talk about 2 cases where we see the diffusion of the New Zealand model. But because they had to put these in unique legal, cultural, political environments, there was some adaptation involved. The other reason why I find them interesting is because they really highlight the role of judges in expanding rights of nature. In both of these rulings, they stem from lawsuits where rights of nature was not invoked by the plaintiffs or the defendants. It was the judges who unilaterally brought in rights of nature. And so it's what we're seeing not only in these cases, but in some other cases, including in Ecuador, where the norms, judges are drawing on these norms that are circulating, but they have to justify it according to their interpretation of existing law, right? So these are rulings that are recognizing rights of nature, even though there are no laws in these countries that explicitly recognize rights of nature. So they're having to justify it by strategically interpreting existing law, and that's producing different pathways or legal doctrines through which rights of nature can be recognized. And so I want to compare these cases because that strategic adaptation produces some variation, even though they're drawing on the same model. And so I want to see if we can draw some lessons, specifically for combining rights of nature with new governance structures, like these guardianship bodies and integrated ecosystem management systems. Because as we heard from Kathy, this is actually where the rubber hits the road in terms of trying to put rights of nature into practice. And so thankfully, Kathy already explained the New Zealand model, so I'm just going to sort of run through the main features again, just to remind us. Only to remind us because, again, the Colombian and Indian cases are meant to sort of we're explicitly cited New Zealand as the precedent and then modeled their results off of this. And so again, the key features of the Te Awa Tupua Act, which relates to the Wanganui River, it was not the legal personhood status. It was the fact that first it defined the river as an indivisible living spiritual being, right? It codified the Maori view of the river. And then that then implied certain intrinsic values of the river, which then implied principles for action, right? And so Kathy talked a lot about that. It did recognize legal personhood status for the river, and then establish guardians who were obligated to protect the river's interests. But in my opinion, one of the most important features of it was this last one. So remember, Kathy talked about the strategic group. There's this advisory group and the strategic group. And essentially what the strategic group was charged with doing is creating this integrated watershed management plan, right? And so this is where all the stakeholders get together. And crucially, what the legal personhood status for the river does is it provides the river a voice as a stakeholder on that integrated watershed management group, right? And so I just wanted to say in response to one of the early questions about what do you do when you have competing rights that conflict with one another? The idea in this case is that those competing rights, how those would be balanced would be decided up front in the decision-making process through this integrated watershed management group so that you can make sure rights of nature principles get taken care of up front through the original decision-making process rather than reactively through the courts, right? Okay, so I'm not going to give the detailed history of the lawsuits. I'm just going to explain some commonalities that make them good cases to compare, right? So both of these cases stem from lawsuits that were in response to the severe environmental damage and human health problems and other environmental problems resulting from industrial extractivism. So you have heavy gold mining and other mineral mining in the Atrato River. And then in the Ganga and Yamuna rivers, it stemmed from a complaint against sand mining and gravel, essentially mining the bed of the river. In response to this, there have been years of community complaints met with just a simple lack of government inaction, right? This then led to a desire to sort of try to create led individuals to try to force the government to do something. They could do something in these countries because both countries shared a specific legal provisions that allowed individual protective actions, right? So in Colombia, you have this process where individuals can lodge a constitutional protective action complaint. And in India, you can only have this kind of ruling because of the fact that the Constitution allows for public interest litigation, which was put into the Constitution specifically because of the history of government inaction in the face of problems that affected society as a whole. I mean, marginalized groups didn't have the ability to use the court system, and so this was put in so that any individual can create a complaint and appeal to courts to force government, the executive branch, to actually address some problem that affects society as a whole, right? And as I said, they're interesting because neither lawsuit originally invoked rights of nature. They were just trying to appeal the socio-environmental problems. And so I'm going to sort of really quickly go through this because, again, Kathy described this idea of Colombia's biocultural rights. So what was really interesting is, so I'm going to try to explain sort of the legal doctrine by which Judge Jorge Palacio, used to justify recognizing the Atrato River as a legal person, because again, he had to base this recognition within existing constitutional law. So just as sort of background, as was said before, right, the Atrato River is in the Choco region, which is one of the most biodiverse regions of the planet. It's 87% African descent, 10% indigenous. And what Palacio said, again, is he said, look, our Constitution lays out this basket of human rights, but their human rights are not just sort of individual rights, they're also collective or community rights. And they relate to not just individual rights for like human dignity, but also collective rights for cultural and ethnic diversity, protections for vulnerable people, and also for environmental protection. It's a quite progressive constitution environmentally, but it really just only recognizes human environmental rights, right? But what he argued was that these basket of cultural, economic, and social environmental rights really comprise this notion of biocultural rights. And what that means is that it's meaningless to talk about trying to defend these kinds of human rights, collective and individual, and cultural rights if you don't recognize rights of nature, rights of the ecosystems on which both the cultures depend, but also individual people in the communities, right? And so he used that as a justification to both declare the Atrato River as a legal person with specific rights to protection, conservation, maintenance, restoration. And again, following the classic New Zealand model, where it created this commission of the guardians of Rio Atrato, you have a panel of expert auditors that are essentially these scientists from NGOs to provide technical capacity to the guardians. And again, but the key features, then you embed these in an integrated watershed management group that's charged with essentially coming up with land management practices that are consistent with the principles of rights of nature. And then there were also orders for law enforcement to eradicate illegal mining. So pretty clear and cut, consistent example of replicating the New Zealand model. I want to spend more of my time looking at the India case, because it's a case where there was more strategic adaptation, right? So just to give you a sense, this is a map of Uttarakhand state. Really just what I want to point out is that it sits on the northern border of India next to China, but also it's right next to this neighboring state, Uttar Pradesh. And in fact, in 2000, the state of Uttarakhand was carved out of the state of Uttar Pradesh, and that becomes important to the story. And just to give you a sense, right, these are the Yamuna River and the Ganga River, flow from the mountains up in there and flow down up into the Uttar Pradesh and flow down through India and through Bangladesh, right, empty out. So it's important to kind of know, I think the story of how this came about from 5 minutes, cool, I can do this in 5 minutes, right? Like I said, you have an individual, guy named Mohammed Salim, who was just mad at these illegal encroachments that were being built along the banks of a canal in the Ganga River, being used for sand mining. And so he appeals to the state, and this was happening on public land that was owned or supposed to be operated by the state's irrigation committee. And there were orders for them to move, and the people engaged in the mining said, well, we bought this land when it was still owned by the Uttar Pradesh, before the split of the states, and so we have title for it. So it got blocked up in this land dispute, and so that led to the creating, the linking of this public interest litigation before the Uttarakhand High State Court to stop construction and alleviate pollution and so forth. Long story short, the judge essentially grants it living status. I'm going to, for time purposes, go straight to the justification, because this is where it gets interesting, right? So it cites New Zealand as an international precedent, but knowing that you have to root it in domestic law, he cites these Indian Supreme Court rulings that recognize legal personhood status for anything that serves the needs and faith of society. And the reason why that language came up was because there had been a previous case for trying to create legal personhood status for Hindu deities, long story. And he essentially argued that, look, the Ganga and Yamuna rivers have similar, if not an equal, spiritual status for Hindus, and therefore meet all the requirements of subserving the needs and faith of society, and therefore, like Hindu deities, should also be recognized as legal persons. And then he also cited the state's failure to fulfill its constitutional protections for the environment. And this is crucial. Because he saw the state as negligent, he invoked the doctrine in loco parentis in order to have court-appointed guardians, right? And so, this is the legal doctrine that exists in many, many constitutions, that when you have an entity, a legal person that can't defend itself, and the parents are negligent, the court appoints guardians, right? And so what happened here, though, is the guardians rebelled because this is where it deviates from the New Zealand model, right? Instead of rooting guardianship in the stakeholders that live around the area, he appointed the chief secretary of the state and the main lawyer for the state district attorney and a leader of one of the government entities for cleaning up the Ganga River. And they were like, whoa, 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 whoa. I don't want to be responsible for the Ganga and Yamuna rivers, particularly, and so they appealed to the Supreme Court. And when I interviewed them and their attorneys, what they said was, look, when the river, floods, the Ganga River floods and kills people, as it does every year, does that mean I'm going to be responsible? Does that mean all the lawsuits that normally go to the Green Court are going to now come against me? And also, what happens in the Ganga River when there are violations down in other states? Does that mean I'm going to now be responsible for those and I have no jurisdictional ability to affect what happens? And so right now, the Supreme Court, as was mentioned, has just stayed the appeal. It hasn't overruled it, but just sort of stayed it while it considers the appeal. And I've talked with members of the various parties, and what's interesting is they all agree that, hey, we're not against this notion that the rivers should have legal personhood status. We just don't like the guardianship arrangement. And so it may be that they can figure out a new guardianship arrangement focused more on this idea of integrating voluntary gardens that are based on community members and embedded then in an integrated watershed management plan. The last thing, I know I'm out of time, but since I promised to talk about animals, and this sort of is a good point to end on, there was just a couple months ago, the same court gave another ruling recognizing legal personhood status for the animal kingdom. What I want to highlight is they changed the guardianship model. Said all the citizens of the states throughout the state of Uttarakhand are declared persons in loco. And the reason why is because when you have everyone be guardians, it can produce this collective action problem, right? As Kathy said, this has been a problem, it may be that if anybody can protect nature, nobody will, right? Crucially, the judges appear to have recognized this, but they're afraid of the guardians rebelling, right? And so if you create a collective action problem against rebelling, maybe it at least will stay in and not be challenged in higher courts. And so these are the kinds of sort of strategic adaptations and political battles that we see. I'll just leave it there. Thanks.
Thank you. Thanks, Craig. I don't think this one's on. Next up is Hugo Echeverria, who will talk with us about Ecuador.
Good afternoon. Thank you very much for the invitation. I am glad to be here. English is not my first language, so I will speak slowly for everybody to understand, all right? Well, I have been invited to speak about the case of Ecuador. Ecuador was the first country, and it still is the first country in the planet that actually acknowledges nature as the subject of rights. We don't have much time, so we will go ahead with this part. This story begins 40 years ago, nearly 40 years ago. In 1983, Ecuador recognized environmental rights to people as an autonomous right, different from health or other constitutional rights. This is interesting because Ecuador, the legislation of Ecuador comes from Spain, and to this date, Spain does not recognize the environment as a constitutional right by itself. In the 90s, there were several constitutional amendments that not only maintain the logic of the environment as an autonomous human right, but extended the right to not only quality of the environment, meaning good quality of air and water, but ecological equilibrium. So a green logic was introduced in the Constitution in the 90s. And this is seen as a first step going towards a less anthropocentric perspective and more biocentric one. And this is completed, I don't know if completed, but this is strengthened in 2008 with a new constitution that literally acknowledges rights to nature. In the morning, somebody asked what those rights are, and this is the actual constitutional text. There are two basic rights, constitutional rights. Rights of nature regarding respect of her existence. Here I make a parenthesis. I refer to nature not as it, but as her, because it's a subject, and in the case of Ecuador is Mother Earth, so it's female. So this is why is there right to integral respect for her existence, all right? And then the second right is right of restoration when the ecosystem is affected. These are the two basic constitutional rights of nature. A little bit of constitutional background. What happened in 2008 is that Ecuador was drafting a new constitution, and the main question regarding the environment was whether to state with environmental rights that is an anthropocentric logic and to make them more effective, or to explore another alternative. In the case of Ecuador, rights of nature. We don't have time to address that. We will gladly do so in the question and period. But basically, the premise here was that principles, rules, and institutions had not fully achieved the goal of environmental protection. It was a little bit of like a challenge, a criticism against not only environmental law, but general law. So rights of nature were chosen, and with the idea, and this is important, Professor Anker said, depending upon how we define rights of nature. The idea, and this comes from a well-known constitutional author in Ecuador, is not to stop development, as many believe, not going back to prehistoric times, nothing like that. It's just to do it better than the Sustainable Development Model stands, to set highest possible standards. That's the goal. Now, I know this is very difficult to conceptualize, what are those best possible standards, especially in a country that depends upon natural resources for the economy. And this is a really a tough practical challenge, a daily challenge. To move on is the indigenous contribution is very important. The concept of Mother Earth is there. But I like to say that it is not the only foundation of this theory. As we have just seen, we have 40 years of constitutional history that supports this idea, as well as contributions from international law, specifically the 1982 World Charter for Nature, which anticipated the idea or the concept of respecting nature because of her intrinsic value. The fact that the Constitution recognizes rights of nature does not mean that this topic is out of controversy. On the contrary, the debate and controversy is very high in the country, and basically you find three perspectives. The two of them are there. You know, there are people who think, the academics, the jurists, think that this is a symbol, and others believe that this is a reality. You have there the arguments, but basically, is, you know, nature is an object, as in all legal systems. Rights of nature debilitate human rights. This is a very strong argument. And rights of nature are not necessary, because you can achieve the same, you can get to the same result with effective environmental laws. That's also a very strong argument nowadays. Those who believe that rights of nature are a reality say that nature is a subject of rights. There's no problem. You know, if you grant legal personhood to corporations, why not doing it for nature? Rights of nature reinforce human rights. This is a very interesting argument. You know, you should not see these rights as excluding, but as complementary. That's basically the idea. And the third one is that rights of nature are necessary because the current legal system is not being too effective to protect the environmental rights. So that's basically the differences in opinion. There is a third perspective, which I call alternative. This is more like a functional perspective, practical. Rights of nature, whether we like it or not, are in the text, are recognized as constitutional rights, so enforcement is to be done, just like any other constitutional right. That's basically a procedural logic. So instead of debating this is a good idea or bad idea, we should be focusing on how to enforce, and we should be focusing on giving these rights with a content. And there we come with 27 cases that to date we have been able to identify. This is not official statistics. This is just an exercise that people have done and come out with 27 cases regarding water, rivers, natural protected areas, and wildlife, basically. We will address only 3 regarding, depending upon if we have time. What time do we have? 7 minutes, okay. This perspective is a contribution from judges and lawyers and trial lawyers. See, and this is interesting because Ecuador does not, Ecuador follows this continental European civil law system, meaning that judges, the ones who interpret the law are the legislators, not the judges. But in Ecuador, something has happened, and the judges are the ones who are giving content to these new rights. And this is good because the ones that are doing this are constitutional judges. They are studying this topic not from environmental perspective, not coming from environmental law perspective, but from constitutional rights. And the outcome is very interesting. The same goes for the lawyers. You know, they argue this topic in terms of constitutional rights. This is an early case. Nobody knows about it because this case was not filed as, this case predates the new constitution. This case is a 2007 case. But the verdict came in 2009, 1 year after the new constitution passed. This case was about the petitioners wanted the court to suspend the construction of a biodigester. Are you familiar with a biodigester? Is an installation that makes biogas out of methane, captures methane, and transform it into biogas. And as a technique, it stands as part of the Kyoto Protocol, which means it's good for the environment. So the court says, did not accept the petition. So they said, go ahead and build the biodigester installation. But the court took note of a concern that the petitioners had regarding the environmental management of the factory that wanted to install this. And the environmental record of that company was very bad regarding how they will discharge waste to the river, to the nearby river. So the court, even though this was not the object of the constitutional action, the petitioners did not address that. The court took note of that and said, look, since we have rights of nature established in the Constitution, we must enforce rights of all parties of the case. This is a quote from the decision. So the court saw nature as a party to the case. And therefore, the court said, we ask for installation of a multi-party commission to monitor the environmental management of the factory. This was resolved in 2009. 2015 to date, in my opinion, this is the best decision that has come from the Constitutional Court of Ecuador. It gives a little content to these new and emerging rights. It's about illegal occupation of a shrimp farm. A shrimp farm is located inside a natural protected area, which happens to be an international Ramsar site because it holds the world's tallest mangroves that grow up to 60 meters. Normally, a mangrove grows up to 6 meters, 6, 7, 8 meters. So these mangroves are really tall. And a shrimp farm, which is an activity that has a very high environmental impact, was occupying part of the land of the natural protected area. So an administrative case took place. The Environmental Authority of Ecuador expelled the farm out of the protected area, and the owner of the farm challenged that decision on constitutional grounds regarding the right of labor and right of development. So the case ended up in the Constitutional Court of Ecuador, and this was a case about property rights versus rights of nature, not property rights versus environmental rights. Okay, the case was about rights of nature, and the stakes were, what will the judges decide, property or nature? Look what the court says. This constitutional court has been emphatic in pointing out the importance of the rights of nature in setting the state's duty to promote respect for all ecosystems. So this is a very important message for future cases because it says that the state has the duty to protect or to guarantee rights to nature because these rights are embedded in the Constitution. And the court keeps saying the constitutional character granted to rights of nature leads to a state's duty to guarantee their effectiveness, and it gives a special role to the judiciary. So it's not in general the state, it's specifically to the judges to foresee for this and guarantee for these rights. And this comes out from the Constitutional Court of the country, which is the top court of the country. I don't have more time. I just want to move on to the latest case, which happened in Galapagos last year. This is not a constitutional case. This is a criminal case. This is criminal law. 6,000 sharks were illegally transported through the Galapagos Marine Reserve, which is a national protected area and a world natural heritage. Authorities seized and prosecuted the case, and a guilty verdict on environmental crime was issued. The judge who addressed this case made this very bold but very strong message. The judge said, that the case will be prosecuted in the context of human rights because you have to respect due process, but also in the context of rights of nature. And she, at the end, she said that in this case, nature should not be seen as the object, but as the victim. And with this, I say thank you very much. We can keep talking about in the questions section because this case is not over. But thank you very much.
Oops. So thanks. While Margaret's bringing up the PowerPoint for Rachelle, I'd like to point out that, Craig set the basis for us and set out some of the parameters where Hugo took us deeply into 3 cases and probably would have loved to have gone into more in Ecuador. So I'm looking forward to your questions as we go through and listen to Rachelle talk about a deeper case in water in Israel. And I want to thank our panelists for sticking to the 15 minutes because this is now making sure that we have time to continue the discussion through questions and answers. So I'll turn it over to Rachelle.
Okay. First of all, I really want to thank Hannah and Margaret for organizing this to give an opportunity. Is it working?
Yeah, we'll just pull it closer.
Yeah. For this opportunity to discuss these issues, which are super, super important, especially on the background of what's going on in the world environmentally. Thanks. I'm going to spend 10 minutes. I'm going to be talking about 2 specific cases that I'm involved with in Israel. And the first one deals with water, and the second one deals with this gazelle that you see on the cover. If anybody wondered who he was, well, he's a story too. So the last 5 minutes, and he has a happy ending meanwhile. So that's how I'm going to divide my presentation. So, okay, so we're going to be talking about the Ein Lavan spring in Jerusalem. This is the spring itself. And the spring flows into 2 pools, which are used for swimming. And what's written here, the text, is from the perfect one-day hiking tour in Jerusalem. Remember, Jerusalem doesn't have an ocean, and it has a large population. It doesn't have much water. It's in the Middle East. And you can imagine that having these pools, natural pools, are a great attraction, and people come and they use them. Oops, other way. Okay. Okay, now Ein Lavan is a spring in the Rephaim River National Park in Jerusalem. And again, the spring flows out of a cave into 2 pools, and the nature reserve is a small area, but it's heavily forested, and it's a cool place to go for a walk, for a hike. And again, it's, okay. I went the other way. All right.
Now
One more. And I'm just showing you some scenes of how people use this and how important it is, not only to nature, but also to people themselves. And people go hiking there, and they go biking, and then dunk their heads into the water after a hot bike ride, and they go camping there. Okay, now what's going on? Even though it's such a great place, the government wants to build 5,000 housing units in its watershed, which means that anything you see going down the hill is going to end up in these springs. Now, they haven't found a real solution. Even though they deny it and they say they're still working on it, they don't know really how to prevent the spring from getting polluted. There's another couple of springs there too, because the drainage basin is exactly on top of and underneath the area that they're planning to build. But that's not stopping the plan. Also, you have to remember that in building, in any kind of construction, there's an impact of 500 meters beyond the boundary of that's being constructed, which means that's garbage, it's pesticides, it's cats and dogs. So it's not like, here's the end of the building, of the construction, and then it's okay. It's not okay. It's still another 500 meters at least where nature is impacted from the construction and from the people and the animals who live there. Okay, now I want to, I just translated that this is from an expert opinion of the Society for the Protection of Nature in Israel, who is objecting to this plan. So what they're saying is really a death sentence for the spring. Now, I just want to show you one of the ways they're trying to figure out how to protect the spring. Tracy, how do I get into that on top? Is there a way of doing that?
Can you?
Hold on. Nope. Anyways, I wanted to show you that they took this. Oh, can you do it, Margaret?
I think we can, yeah. Oh, there you go, from the
Okay,
keyboard.
it's just half a minute. No, you have to make it big. You can only do it.
Yeah, I think she's going to put it into
Okay.
a browser.
No, I don't want to give up my minutes anymore. You could just enlarge it and then click on it. That could work too.
It's just starting up the internet. We'll get it. We can give you, we won't take this off your time.
Okay, as long as you,
We'll
it's
reset the
worth
clock.
saying. You can just enlarge it, put it on the whole screen, and then you click on it, and then it'll open. Yeah.
It's just not activated in there, so I'm trying to open up.
All right, if anybody wants to see this, I'll send them the link. Anyways, it shows how they take this green, bright green liquid, and they put it into certain points in the area under which is supposed to be constructed to see how it's going to affect the spring, to see if what's going to go on top is going to reach underground and finally reach the spring, and it reaches the spring. The spring turns this bright, bright green. But if I have time at the end, I'll be happy to go back to that. Margaret, you still trying? Is that it?
We're almost there.
Wow, thank you.
Computer's just been working so hard all day.
Just did something new. Is it a short video?
Really short, just, not even a minute, so maybe it's a waste. We're wasting too much time on it. Should I just go ahead?
Just go ahead.
Yeah,
Well,
so-
every time we say we're going to go ahead, it's going to take another step.
All right,
Let's see, maybe at the end it'll be ready.
okay.
Okay. Go back to you.
Okay, and as I said, this really hasn't stopped the government, the planning committee from moving ahead, and this is really important, and it really conflicts. I mean, it's totally the opposite of what Hugo was telling us about the judge. So their decision is, okay, these springs are really important ecologically, historically, culturally, recreation, and also they have huge recreational value, yet even if we don't prevent it and we can't protect these springs and they dry up, who cares? The public needs this area for building. So that's kind of like decision. Yep, they're important, and as we'll see, they're also protected by law, but public needs them more for building, for homes. Okay, so let's just go over why they're saying this. So Israel, of course, is in the Middle East. It's an arid region. Its population is bursting. I mean, it's crazy, just taking off so fast, and nobody wants to talk about it, even though a friend of mine wrote a book about it called The Population Explosion in Israel, and someone better start thinking about it. Economic growth and consumption is growing even faster. High standard of living, intensive agriculture, chronic water scarcity. I mean, it sounds like a recipe for total disaster. And they keep on building and having more babies. And just to give you an example, Vermont has a population of 600, well, this is a couple of years ago, so 609,000 on a land area of 9,600 square miles. Israel has a population of 8,700,000 on a land area smaller than Vermont. So just to give you an idea of the pressures that are going on there for construction. Oh, I'm sorry. Okay, so that was just for comparison. Okay, so Ein Lavan, what kind of legal status does it have? Well, it's a protected area, so no one's going to come into Ein Lavan and start building right on the spring because it's part of a city park, it's part of a national park. But the question is, who protects it in its watershed? I mean, if you can't protect the watershed, you really can't protect the stream or the wetland or whatever, any kind of body of water. So Israel does have rights of nature for water. Now, Israel's law evolved really, it started out in 1959. This was the height of the absorption, and you have to remember that Israel was established in 1948, and its first years it was absorbing any survivors of the Holocaust, which was a huge effort, and then other people started to come in from all over the world, Jewish people from all over the world, and the big issue was water. So in 1959, when the water law was passed, water was seen as a commodity for development. In 1971, remember 1971, 1972, you had the Stockholm Conference, so it also affected Israel. So a pollution prevention chapter was added. In 1992, we strengthened the pollution enforcement. And then in 2004, I just want to show you how it evolves, nature's rights to water. So it is there in the law. And just to show you, it was added in a section, these different sections of the economy and the urban sector, who all have rights to water, and then they added conservation, restoration of nature and landscapes, including springs, hold on. Okay, springs, streams, and wetlands. Okay, and all this was a response to very, very severe problems of water pollution in Israel, because they had to absorb a huge population within a couple of years. The streams were turned into sewage canals, and industrial sewage and municipal sewage. And that was the result. I'm happy to say that you're not going to see these pictures anymore. The situation has really improved, and this does not happen anymore. But 70 years of intense industrial, agricultural, and urban development, these were the results. Okay, so here is the evolution of the concept of rights for nature, for water in Israel. And it really started out, what's interesting here is that this was a government initiative. The 2000, the government decided to allocate 50 million cubic meters of water for stream restoration. In 2002, I was working for the Environment Ministry, and I was asked to write an article in Hebrew on rights for water. And it was published. I don't know how much of an effect it had, but it was it was like a consensus that we have to do something, and it's not enough what we have right now. And then in 2002, water was defined as, that's 5 minutes? Water was defined as a legitimate consumer of water by a government master plan, again, the government. And then 2003, a government document, Nature's Rights to Water. It was a government policy document, and now this is important. It recognized that streams' right to water means entitlement to their own inflow, not from the national grid, but from their own natural waters. And the concept of streams' right for water was now driving government policy. total? Okay, the original intention was to declare wetlands a legal entity, but that didn't make it to the final version of the amendment. So you get rights for nature, but even though the government wanted to do, when I say the government, it was the Parks and Reserves, the Nature Reserves Authority, they weren't able to get this through the parliament, through the Knesset. Okay, so this also maybe connects to what Hugo just said. Ein Lavan is really a conflict between rights of humans to habitat shelter and rights of nature toward a habitat shelter. Israel, again, doesn't have enough land. They're thinking even about building islands, artificial islands like Dubai in the Mediterranean, but thank goodness that was rejected. Okay, and what I want to bring up here, I don't know how you'll react, but I'm just sending it out. There's a question. Does this focus on human rights, the right to shelter, to water, to property, to employment, to a family? These are all good things. It's things that we all want. We all feel that these are inherent rights. But do they also encourage economic growth, consumerism, population growth, which are really the underlying causes of ecosystem destruction, and particularly in a country like Israel, which has such a large population on such a small land area? And of course, who suffers? Nature. Other examples would be conflicts between humans' right to water and streams' right to water, which I'll also touch upon. So Israel's right of nature amendment to the water law was really leveling the playing field, was development of the concept of rights to prevent human misuse of water that nature needs for its survival. If humans' rights to water are legally recognized, so should nature's rights to water. A couple of more minutes. Okay, and I just want to point out something that I just came across, which I found really interesting. Has anybody read the book *Sapiens* by Yuval Noah Harari? It's a short history of our history. So he says, human laws and norms have turned some people into slaves and others into masters. And the truth is, it's also true about laws and norms that turn nature into a slave by turning it into a property. It's master versus slave relationship. It's not just between humans, it's also between humans and nature. And that's what our current laws, I feel, have done, has really turned nature into a slave. Okay, so it's been 14 years since the amendment passed, and let's see how it's doing. So the government does have a very intensive, strong program for bringing back, for restoring all the streams that had been so badly polluted over the years. Just some pictures. And the right to water has helped. Okay. 1 second. But we're still overgrown. We're still overpumping. And we have a terrible drought. That's also, 1 minute, also because of climate change. And the solution that the government has found is we don't have enough water, let's make more water. So Israel has a very intensive program for desalination. Today, 50% of the water comes totally from desalination, desalinated water. They have 5 desalination plants along the Mediterranean. And within a couple of years, close to 100% of the water will come from desalination. Now that sounds great. You feel that that's a good thing for the streams, at least for nature, because then the streams get back their own natural water. But the thing is with desalination water, it just kind of like encourages people to use more water. It encourages the economy to grow. People say, well, there's so much water, so we can have a bigger family too. There's no limitations on this. So it's kind of like a never-ending cycle that keeps on going back and forth. Do I get 2 minutes because of the... Yeah, okay, all right. You at it? Okay. This is just a quote from a book by E.O. Wilson, Consilience, which I think is a really wonderful book. and humanity's best efforts will include every technological fix for an overcrowded planet that genius can devise. The water crisis might be eased by desalination of seawater with energy from controlled fusions, but be careful. Each advantage is also a prosthesis, an artificial device dependent on advanced expertise and intense continuing management. As these man-made procedures thicken and interlock, they enlarge the carrying capacity of the planet. Human beings expand to fill the added capacity, and the spiral continues. That's a problem with technology. And again, there's a government decision from June to establish another desalination plant, 2 more desalination plants, 1 in the north to allow natural water to go back. So again, it's more. And does Ein Lavan have standing to petition the court? I wouldn't go, I mean, thankfully, I think this is going to be solved politically, so we might not even have to go to court, excuse me. We don't have very proactive courts in Israel. I mean, listening to what's going on in India and Ecuador and Colombia, I'm really jealous. I can't see that happening in Israel, unfortunately. On the other hand, politics sometimes saves the situation. So right now, it's kind of in limbo. And of course, there's a public trust and rights of nature. So the public we could probably use that too, try to develop public trust in which the public would be the trustee for nature, to protect nature. Just a few words on an animal. In 2005, the Israeli gazelle petitioned Israel's High Court of Justice against approval of a development plan on its gazelle habitat. Now, we argue that it's a protected species and all that, but we definitely don't have rights of nature for animals in Israel. And I'm happy to say that the gazelle won, and its habitat is still undeveloped, and the gazelles, we have close to 100 today. But what I want to point out is it won, but this is like a totally different kind of paradigm, because the court didn't mention the gazelle once. It didn't throw the gazelle out of court. It didn't give us court fees. We weren't punished for bringing the gazelle to court. It found different arguments to make sure that the government wouldn't build on the gazelle habitat without even having to mention the gazelle. So that's another kind of way of doing it. There are all different kinds of models on how to protect nature, even if you don't have a proactive court, even if you don't have specific rights. So it's like you can be very creative and try to do different things. Okay?
Thank you.
Thank you.
All right, again, thanks to our panelists for giving us enough time to answer your questions. So it's now time. Do you have, I see the mics are going around. Amanda has one, Rashida has one. There's one here.
A question for Craig. I'm interested in that judge in India. Sometimes I feel like rights of nature really needs just someone who's got a lot of guts. And is that the case with this judge? And do you know anything about his character and his background and that sort of thing?
Yeah. Both Colombia and India illustrate essentially judges with guts. Not coincidentally, Judge Jorge Palacio had retired right after issuing the Atrato ruling. And those were close decisions on the court. It was like 4-3. Long story short, so absolutely, it takes some guts. But I think the thing about India that you have to remember that puts it in some context. So I mentioned this is happening through the context of public interest litigation in India. Public interest. There's a long history, decades now, of environmental public interest litigation. And so it is not that unusual to have judges in India taking strong stances for environmental protection, because when you think about the very purpose of public interest litigation, it's not hard to see why a lot of those claims came around the environment, right? And so there's this long established history of this that's now accepted that gives it a certain amount of credibility in India. So to a certain extent, he's not really being any more bold than many judges who have issued very bold rulings in response to environmental public interest. I think it's more exasperated than bold. It was just incredibly exasperated at the lack of government responsiveness to court rulings, and then was just looking for another tool and to make the point, and the Wanganui ruling came out, and so he's like, I'll try this.
See another question?
Yeah, so just before I ask my question, I can just add something a little to that answer. Craig's exactly right, but that particular judge is also very well known for being a very activist judge and has bucked the trend on, like, dowry burning cases and things like that. So yeah, the answer is yes, but also all the other things about activist. So I was just going to take up the mantle and invite Hugo to tell us some more stories, because that sounds like there's some fascinating things. He said, I've got more examples, just ask me. So I go, okay, I'm asking.
One more case? Well, as I mentioned, there are over 20 cases. Not all of them are successful, I must say. But most of them are. I just want to take, as an example, the last one, the Galapagos case. The case involves over 6,000 sharks that were not caught in Galapagos. They were caught in the high seas by a foreign fleet. But they entered the Galapagos Marine Reserve, which is Ecuadorian territory. And in Ecuador, illegal transportation of wildlife is considered a felony. Okay. So the case was prosecuted in Ecuador, and a guilty verdict passed. The guilty verdict included prison time, a fine, a seizure of the vessel, which is a huge vessel, very, it's valued in millions. It's a factory vessel, basically, and a payment of restoration. And this is when it comes interesting, because the defendants argued that since the fish was not caught in Ecuador, why they are being asked for restoration? So the judge said the calculation was the number of hours that they entered into the marine reserve. And the calculation was set upon the value of the shark regarding in Galapagos. There are studies that says that a shark in Galapagos in his or her lifetime the economic cost is $5 million. And that's only and that's actually from California University, UCLA estimate, and only regarding tourism value, not biology value as being the top predator. So the calculation was over $6 million. The case went to appeal, and finally, and right now in February, ended up in the Supreme Court of the country. The Supreme Court is like the US Supreme Court, the top court. And the case is now being addressed from the perspective of who should pay, whether or not restoration is in order, and who should be responsible to restore. And also whether or not the vessel should be seized. Okay? Because the owner of the ones that are that were responsible for the crime is the captain of the vessel, but not the owner of the vessel. The owner of the vessel is in Hong Kong. So they say, how come you seize my vessel if I am not a party of the case? On the other hand, Ecuadorian authorities are arguing that the vessel was the means of the crime, and therefore it should be seized. At this moment, and this is something I am happy to announce, in December, probably earlier, this case is about rights of nature. That was set by the judge on the first place. But it ended up at Supreme Court as being a procedural case, not very far away from sharks, very far away from Galapagos. Not even right, and you're very far away of that. It will be about seizure and about restoration. So with a group of people, right now we are, well, not right now, I've been studying this for 3 months, whether or not to apply Article 71 of the Constitution that Professor Catherine displayed in her presentation, that gives a standing to anyone to go to ask any public authority the enforcement of rights of nature. So this is not procedural rule on standing. This is a right that the Constitution provides to anybody to act as guardian of rights of nature. So I am now studying the possibility of applying for the first time in Ecuador at the Supreme Court level, because I did so in 2011 in a Galapagos case, and it was admitted an amicus curiae in 2011 on behalf of the sharks, but it was admitted on a first level trial judge. So now this is Supreme Court. They are very formal. And procedural rules are very strict. And this case, this did not go to the court as rights of nature case. I have come to the conclusion that it is possible to apply Article 71 in this case and to argue before the court, even though we are not procedural parties, to ask for the court to address this case from a rights of nature perspective, specifically when it comes to the right of restoration. By this, I am saying that what the judge ordered in the first level, meaning that transportation of through the Galapagos, even though the fish were not caught in Galapagos, allows for restoration. So this will be filed by the end of November or maybe the first week of December. And this is a concrete application of Article 71 of the Ecuadorian Constitution.
Yeah, thank you. We are down to the last moment, but we have time for one more question, and then, of course, during the snack, we can speak more informally. I see a question here. Thanks, Rashida.
Okay, so a lot of times it's industries that are responsible for, the destruction of nature, whether it's with overfishing or poaching or, pollution, anything like that. And often these industries hire people locally and just like common people who need jobs, who might not have any other options to, support themselves and their family. So my question is, how can we find a balance between applying the rights of nature and supporting the rights of nature and not causing people to lose their livelihoods that might not have other options, I guess.
For who?
I think for
Anyone?
everybody could take a shot at that. Good way to conclude.
Go ahead, you go first, I'll go second.
First of all, I don't think granting someone's livelihood could ever be an argument for destroying nature, because once nature is destroyed, there goes their livelihood too. So that's the first answer. Because we're so dependent on nature and on ecosystems and what they give us, that it's totally like it's a short-term consideration. And what I've discovered is that the more we put into protecting nature and protecting ecosystems, the more jobs it creates too. So these jobs have to go. They're totally unsustainable, and I don't even see it as an issue. That's it. We've reached the point where we can't be kind anymore, and it's not a matter of being kind. It's a matter of saying this job cannot be done anymore because it's hurting the planet, it's hurting nature, and let's find other things that we can do. So that would be one of my answers.
Yeah, so I guess I'll say 3 real quick things. So one, this issue has been thought about and addressed, like including in Ecuador and Bolivia. So, Ecuadorians, as I've been told, when thinking about the Constitution, they're a major oil exporter, right? And they recognize that oil is going to run out. Their amount of oil is going to run out in like 10 years. So do you want to extract every last bit of oil and ruin the biodiversity, or do you want to recognize the biodiversity as a potential alternative source of wealth or revenue? And in Bolivia, you're having, a lot of locals are choosing who you might think of being defenders of rights of nature, are struggling with that problem because the alternative is a coca production in some parts. And so there does have to be an alternative created, right? And so I guess the short of it is, and this is one of the takeaways that I was trying to make, if I had more time, I would make it more explicit, which is that it's not enough just to create the legal personhood status or the guardians. Those are kind of like the easy things. What's way more important, the lesson to me of like New Zealand and Colombia and in reverse in India is that the most important piece is to then embed these in governance institutions, right? And the new governance institutions, the legal personhood status matters for the purpose of giving the ecosystem a voice in these decision-making processes. But you're going to have to make decisions about how you're going to restructure the economy. There are going to have to be new types of jobs. So in the energy sector, if you want to keep the oil in the soil, you have to create governance institutions to expand renewable and other options. And
I just want to add that that's a really nice question and was addressed in the early Vilcabamba River case, which actually precedes. It's like the background for the Atrato River and the New Zealand River as well. This is a 2011 case. Basically, what happened is that the authorities were improving a road, but they were using the river as a dumping, is that correct? Dumping site of the remains of the construction. The argument of the authorities was that, the local authorities was that the improvement of the road will mean direct jobs, local jobs, and better conditions for development of the region. So the court says, we are not, yeah, that's a good argument, and we are not against that. But we are just saying that for you to build that road in better conditions. So not to exclude, but to complement. And this is in a judicial decision, and basically it's trying to find the balance in case-by-case experiences.
Well, thank you, everyone. And on behalf of the Vermont Law School faculty and staff, I want to thank Craig, Hugo, and Rachelle for being with us today and teaching us so much.